Hi, thank you so much for watching. If you are new to this channel, thank you so much for taking your time to actually watch our videos. Don't forget to subscribe so that you can join the community. And if you are a subscriber, thanks again for taking your time to watch these videos. I hope you do enjoy the video. Don't forget to comment below, give the video a thumbs up, and share it with your friends and family. All right, so in our estate planning series, in our last video, we spoke about a will. What should I put into my will? Today, we are going to be talking about children in my will. All right, so if you are someone that has children, be it minor or major children, you need to be able to make provisions for your children in the will. So, who is my child? Now, your child is someone that you gave birth to or somebody that you legally adopted. They qualify as your children. So when you write in your will, my children, when you just use the general word children, we include everybody that your natural children or your adopted children. So if you maybe have other children that maybe your partner doesn't know about, and in your will you just write children, and it happens that you pass away and your partner doesn't know about your other children, even those children that you didn't mention to your partner are entitled to inherit, because you just said, I bequeath my house to my children. But if in your will you specifically say them by name, then the ones that you've listed by name will be the ones that will inherit. Okay, so another thing about children, you need to consider the age of your children. How old are your children? Are you dealing with adults or are you dealing with minors? So a minor would be someone that is under the age of 18. So according to law, because they are a minor and they're under the age of 18, they do not know how to make their own decisions. So what would normally happen to their assets is if you leave them with something, right, in your will, but you don't necessarily put a trust provision in the will to what should happen to their assets. What will happen is their assets will be administered by the guardian fund, right, which is controlled by the government. And they can only get those assets once they reach the age of 18. So hence that it's always important that when you are doing a will, always put a trust provision where you will state and say that, okay, I have 3 children and all of them are under the age of 18. I want to create a testamentary trust that will hold their assets, and that testamentary trust will obviously, administer and control their assets until they reach a specific age. So the nice thing about having a testamentary trust is that you can put an age to a testamentary trust. So if you feel like your kids by the age of 18, they are still too young to be getting these, houses and cars and hundreds and millions of money, you can put an age to it. You can say, for example, I leave 1 million to my daughter Teto, and if it happens that she has not turned the age of 21, then I ask that a testamentary trust be created, and she will only inherit everything after she turns 21. So between now, when she is however old she is, 3 years old, until the age of 21, her inheritance is controlled in a testamentary trust. So a testamentary trust is obviously a trust, that you would create, where now you would nominate a trustees. So trustees will be people that will control and administer the trust, right? So they are the ones that are going to be responsible for things such as, paying school fees for the child, taking care, ensuring that the child has enough money for their basic needs, ensuring that, for example, there's like money, like your child has money to live until they turn the age of 18. So everything is administered through the trust. For example, let's say, for instance, now your child wants to buy a car, right? They have R1 million. It's administered by the trustees, but they're not 21 and they are 18 and they want to buy a car. So what they would do then is they would go to the trustees and contact them, and they tell them that this is what I need. Then the trustees would meet together and decide if is it beneficial, is it not beneficial for your child to actually get a specific thing. So hence, when you nominate your trustees, it's always best for you to nominate somebody that you can trust, somebody that is loyal. And it's also nice to nominate like an independent person to become a trustee, because an independent party, when an independent party is someone that is a trustee, they're not emotionally attached to your child, so they can make clear decisions to know if this would be good for the child or if this will not be good for the child, and they also make sure that, if, let's say, for instance, you've nominated maybe 3 trustees, right, and they're all family members, and there's an independent trustee, because they're not emotionally involved, it's easy for them to make, like, to decide, without being emotional about it. So always have an independent trustee. It's just a recommendation. You can have an independent trustee. You don't have to have an independent trustee. It's up to you. So the trustee then, so now in your will, what we do is there would be instructions on how the trust should be administered. So you would write down and say that the assets in the trust, for example, let's say, for instance, you have a house, right? But you know that, you live in this 3-year-old, and this 3-year-old is not going to be living in your house. They're most probably going to be living with their grandmother. What should happen to the house? So you would clearly instruct and say that all rental property, rental amounts, that's what should happen to my house. It should be rented out. So you would specifically write in that will what should happen to your house before your child turns 18. And another thing I've actually noticed is that sometimes you find that it's your house and you're living with your parents, but the house will be inherited by your child. So you can actually write that you can give your parents living rights and say that my parents, as much as Tintalo is Teto's going to be owning this house, she cannot kick my parents out. You're giving them living rights, that my parents are allowed to live in this house until they decide to go to an old age home or until they pass away. So you can actually give them living rights. But anyway, let's go back to the testamentary trust. So now this testamentary trust is what is going to help control your kids' assets until they reach a certain age. Another thing is that it's also very important for you to terminate the testamentary trust and to put a realistic age. I have seen clients put ages such as 40, 50 onto their trust. Is that really realistic? Because don't forget that if you are gonna only let your child inherit by the time they are 50 and you've nominated an independent trustee, the independent trustee is the one that's going to be charging you fees all those years until they reach the age of 40. So before you put in an age, decide which age is appropriate for my child. Normally pick an age based on your child's maturity. If you know that your child is a very responsible child, at the age of 19, they will be responsible. They're not going to go gamble the money away. Then you can say at the age of 19. But if you know that, your child is not so responsible, then you can put an age until you feel that they will be responsible to handle such a big inheritance. And the nice thing about testamentary trust is if, for instance, you have a child that has special needs, you can put in an age and say that, my child will inherit until they are this age. And then, make provisions in the testamentary trust that my child has special needs, they should go to the specific school, and the trustees will be able to do that. And the nice thing is you can even tell the trustees to invest the money. If you have a lot of capital, they can actually invest. You can instruct them and say, invest the money until they are 21, and then they will get it at the age of 21. So that is a testamentary trust. There are trustees that you will nominate for your testamentary trust. So now let's talk about the guardian for children. So guardian. So a guardian is someone that you are going to be leaving your children with when you pass away. So most of the time I've seen people leave their family members to become guardians. So when you're nominating someone to become a guardian, it's always best for you to speak to the person beforehand and see if they are willing to become a guardian for your child. Because when somebody takes over the responsibility of your children, it is quite a huge responsibility for them, because what happens if, for instance, the money that you left your child runs out and they cannot afford to take care of your child anymore? What's going to happen to that? So discuss it with your guardian, let them agree, and also make provisions for that guardian, leave enough money for them to cater for your child. And a guardian should be someone that you trust, and you know that this person is going to be looking out for your children's needs. You know, we've seen so many cases where people are nominated as guardians, and what they tend to do is they would neglect the child, or they would, you know, use the child to get money for their own needs. So if you're leaving, or you are nominating someone to become a guardian, is that person a trustworthy person? Is that person really looking out for their own needs or the needs of their children? So those are some of the things that you need to consider once you are nominating a guardian. And who's going to take care of your kids in case this person passes away that you've nominated? Is another person willing to take care of your children? Right? So you need to make proper provision. You need to pick the right person who is mentally capable of taking care of your child, and also make provisions of where they're going to stay. Is your children going to live with the guardian, or are they going to live on their own? What's going to happen when your kids go to varsity now? What's going to happen once your kids start, you know, when they can actually inherit the money? You know, what's going to happen? Does that mean that, you know, the guardian does not have the responsibilities anymore to take care of your children, or what is going on? So just sit down, nominate someone, pick someone that you trust, and have a conversation with them and say that, you know what, if it happens to pass away, please take care of my children, and I'm going to leave you this amount of money to help you during that period of time, and you can take care of my children until they reach the age of 21. After 21, they are on their own. So always do that in terms of children. Now, another thing that we need to consider when coming to children is your child needs to be a natural child or an adopted child. I've seen a lot of cases or a lot of requests where people actually tell me that, I'm divorced, or me and the father of my child, we are separated, and I don't want them to have anything to do with my children. Guys, please note that in the world, because the father of the child or the mother of the child is the natural guardian of the child, they have more rights than the actual guardian that you do nominate. So in the will, we actually do right, and we do say that failing the natural guardian, you know, that's when you can nominate your friend or your mother or your sister. But if the father of the child is there and still alive, they still have the rights to the child, unless if you are the one that has full custody of the child. So just make sure that, you know, that is sorted out before you pass away, because sometimes you find that, yes, you have left your sister to become the guardian, but the father of the child is still alive, and according to the law, the father of the child has legal rights to this child. So while you are still alive, maybe you can come into agreement with the father and say that, hey, I've nominated my friend, my sister to become guardian. Yes, you can have access to the child, you know, but they will live with this particular guardian. So just make sure that that is done, you know. Make provisions for that in terms of your children. Please do not also forget that sometimes you do outlive your children. So what should happen to your assets? Should it go to your sister's kids or whoever is left behind? So that is in terms of your children. Make provisions for your children in terms of a testamentary trust and in terms of having a guardian. I hope you enjoyed this video. If you like this video, please do give it a thumbs up. Don't forget to subscribe, like, and share it with your friends. If you do have any questions, or you want me to address certain questions in terms of children and testamentary trust, please do let me know. You can send me a message on Instagram, or you can send me a message on Facebook, and I'll be happy to just address these questions. I look forward to seeing you in the next video. Thanks again.